now when you mention international law, I will start now another topic, Mr. Sunga, and maybe try to connect the two. And this is my old fascination with the international criminal law. And you are sitting in Rome, which is very important beside Hague in this respect. And the experiences of ICTY, so International Court Tribunal, so Criminal Tribunal for ex-Yugoslavia, what we were witnessing there was that the prosecution used to use evidences provided by the powerful states. And on the other side, those states were not in duty of giving all of the evidences they would have on a certain topic. And that would be a big discrepancy that we could have witnessed. So basically, in a regular court procedure, executive is obliged to hand over all the evidences they have. So whatever you have, regardless of the fact it goes in favor of this or that side, you simply have to hand over. In these cases, you can make a nice patchwork to hand over whichever you like to hand over, and then to make, so, and I cannot resist the feeling that in ICTY, I have never seen anyone convicted who shouldn't have been, ever. Personal statement. On the other side, another personal statement, I know for many of those who were not even mentioned, not to say convicted, and that should have been there. And for me, the key reason is this ability. So we are sovereign when it comes to one aspect, so we can sovereignly decide what we are going to hand over, but then this international tribunal will decide. Somehow this is it play around of justice, this non-universal status?
Well, I want to maybe, you wanted to connect the two things, and maybe I could make a comment a little bit that covers both Davor's very interesting intervention and the question you just raised about the ICTY, and it centers around both of these things, sovereignty. Now, sovereignty, and you mentioned Westphalia, the idea of this states coming up and being sovereign and equal under international law, and we know the history of that since 1648. There are some exceptions to sovereignty. One of them, first of all, is human rights. Human rights does not fall within exclusive sovereign jurisdiction. And the reason I can tell you that very confidently is very simple. It's in United Nations Charter, Article 1, Paragraph 3, elevates human rights to a matter of international legal concern. And just to remember that the reason that was done was not because states like to be criticized for their human rights violations, although they these days accept to be criticized even if they don't like it. It's because after World War II, it was realized that promotion and protection of human rights could not be left to sovereign jurisdiction of domestic states, of domestic jurisdiction, sovereign states, I should say. So, in other words, if you leave it to Nazi Germany and say, well, it's no problem, this is not our issue. Sorry, that's an international matter, because when you violate the rights of individuals and minority groups in a country, this can destabilize the situation so badly. Not only is it wrong in itself, but number two, it causes great regional instability and threat to international peace and security. And you know that very well from the Yugoslav experience, or from Rwanda, or from anything else. So, human rights had to be elevated as part of the United Nations peace strategy. Otherwise, we're going to go right back to a resumption of World War II. So it was very urgent. The first purpose of the United Nations is maintenance of international peace and security. And secondly, related is also human rights promotion and protection, which is not a matter of sovereign states only. Countries, when you get down to it, it's up to them to apply and implement international human rights standards so much at the governmental level, but the obligations that they have, and their legal obligations, are at the international level. So that's number one. Number two is that international criminal law, since way back to ancient China and India, thousands of years ago, it has its roots that go all the way back and all the way right up until the present day, to say that certain types of crimes, certain types of acts have to be qualified and have to be understood and recognized as crimes under international law. It doesn't matter what your jurisdiction is, who committed them, and they have to be prosecuted and punished. Now, your right to raise imperfections, or maybe even some more serious faults of the ICTY, and one can do the same for the ICTR. One can complain about the operation of prosecutorial discretion and the operation of courts and the use of evidence, etc., in just about any court, and one should do it. That's what keeps the court on its toes every time. Justice is not very easy. It's not very easy to do. It's not. Justice is very, very difficult. It's hard to. There was no way the ICTY was going to get everybody. Rwanda only prosecuted 70 people. There are thousands of perpetrators. But the purpose is to say, when domestic jurisdictions are unwilling or unable to prosecute really serious crimes that are so serious that they're recognized as crimes under international law, there has to be an international level criminal tribunal, maybe an ad hoc one like the ICTY or ICTR, or a permanent international criminal court. So the rationale behind it is solid. I think probably you agree with it. How it actually, you mentioned specifically that some of the big powers chose to share some information and not others. Maybe some of that other information might have been exculpatory, etc. I agree with you about that. That's a concern of mine as well. When governments try to manipulate an international organization, an international criminal tribunal, wherever it is, it's a big cause of worry, because then that is going to possibly undermine, in this case, international criminal justice or international justice. And it's difficult sometimes to resist that. The ICTY at least had very strong powers, because it was established under the Chapter 7 powers of the United Nations Charter by the Security Council. Its rules were binding on all UN member states. And there were judges and brought from all different countries. Really didn't know where necessarily Yugoslavia was on the map necessarily. I mean, they didn't have any connection, etc., with the conflict or any particular bias. And the staff equally is brought in. I think they had 110 countries, countries, I don't forget the number, but it's a huge number of different nationalities, and prosecutors from different places, etc. So I didn't find that, because there's allegations also of bias and partiality, etc., etc. I personally haven't been very convinced of that, but I have seen, and I agree with you, that the big powers try to get their way with the ICTY one way or the other, whether it's the United States or Britain on one side or Russia on the other. And I don't like that, and it's got to be resisted by staff and the people who follow their principles, by judges. And I think they managed to do that most of the time. But there's certain other things that bother me. I mean, nobody was prosecuted for the NATO bombing of Kosovo. I think there could be some war crimes cases out there where they should have at least been brought. If you want justice, it should be very, very even-handed. If some NATO powers are involved in war crimes in one way or another, they should have also been brought before the ICTY. So there's a lot to complain about, but I would rather have an imperfect, even flawed international criminal tribunal than not have it at all.
No,
that people get away with murder.
That is definitely for sure. I would say, I told you in the beginning that I don't have criticism against any judgment, more or less, that someone was prosecuted as a war criminal. Only elect some people there. That would be my main concern. However, the key fear, to be honest, that I honestly have is when you mentioned Westphalian concept is that we are using 17th century concept in solving 21st century problems. And all of us living in Europe in this moment, I would really be afraid of this overemphasizing of national sovereignty on expense of national sovereignty, on expense of EU sovereignty, or on expense of international principles. And this is something. And when we talk about international justice, let's go to primordial sin, basically, that we know in the last 70, 80 years. We should talk openly, I suppose, whether Dresden bombing, was it a war crime or not? So,
oh, sure it was. Sure it was.
Having in mind that Nazi regime was probably the worst thing, at least in my knowledge, the worst thing that appeared on the face of the earth. Nevertheless, the bombing of Dresden, then bombing of Cambodia in I think it was Nixon administration, that a war crime. So basically, what
about Nagasaki and Hiroshima?
Hiroshima, of course. And what we know as a pattern of behavior is that who made it is a very important thing, unfortunately. And that national sovereignties were covering themselves, their traces, in order, and then basically really not allowing international principles to come on stage in full. And yes, I agree that it's better to have this non-perfect system than not to have it at all. But I would strongly advocate, and this is a question for both of you, maybe Davor first, if you agree that we should be really in support of more international entities that would support international values, having in mind that COVID-19 is probably only the beginning, or only a slight warning for the potential international crisis that we will or may be faced in future. Having in mind the level of globalization, the population that we have, I suppose much harder challenges are ahead of us. If we would not be equipped with the proper universal level, or maybe this regional EU level bodies, we would not be able to respond. Davor, what's maybe...
Well, a couple of things just to say about the previous discussion. As much as I think we all admire the existence of certain international norms and let's say human rights, something should be said about that. First of all, Lyal described the context out of which the whole idea of universal human rights came, and it's perfectly correct. The problem there is also that United Nations Declaration on Universal Human Rights is a result of political consensus. In other words, human rights or any other kind of legal norms never fall from heaven, or at least nobody seriously claims that that's the case. It's not by some divine declaration, or it's not there just as some kind of natural thing. It is a result of a political decision, and those human rights that we have now, or most commonly how they are most commonly understood, going back to the UN declaration, they are there only because certain states agreed on them and left out some other things that they didn't think was important at that time, or that interfered with their interests, and so on and so forth. So those human rights are something that's politically conditioned, and it can be, and I think it should be, expanded to include many more things than they're written in this original document. So that's one thing, and that's a problem with any legal norm, that I know lawyers very often like to think of them as ontological things, and sometimes it would be nice to have them as ontological things, but unfortunately that's not the case. Unfortunately, they depend on political power and political will to be protected and to be enforced or not. And that's also then the case when it comes to these international tribunals. There is something imminently problematic about how it's implemented. I do agree that it's a very good idea to go after some of the major war criminals in the world. The problem is what kind concept of justice do we have in mind when we know in advance that that justice will be highly selective? It won't be universally applied. In other words, in the case of international law and international tribunals, the only way to impose and reinforce these norms and go after those who are mass murderers, commit genocide, and so on and so forth, is that powerful states allow that to happen to less powerful states and less powerful agents. In other words, powerful states always excuse themselves, and that in advance creates this situation of injustice. No major perpetrator of major crimes after World War II has been actually brought to justice. More minor ones, yes, those who either operated with support from some powerful agents or didn't have that support and so on. But most of the major crimes that have happened over the last 50, 60, 70 years have not been actually brought to justice or any international court. And that is a problem. So it is similar to a situation within a state when you would have a legal system that would just go, or primarily, or 80% of times go after poor and those who are actually don't have power to defend themselves, while the rich and the influential within a society stay in the privileged position. No matter what they do, they won't be brought to justice. So I wouldn't call that a system of international justice. I would call that a system of injustice, both locally and internationally, with a full understanding that even those who are poor and they commit some major crimes should be brought to some kind of institutions, to the institution of the law and the court. But that is just very one part of the story. It actually creates an illusion of some kind of system of justice, while in actual reality we talk about system of injustice. And this is something that was supposed to be resolved through United Nations. And going back to your question, how to deal with that, well, the idea of the United Nations was to actually create this international institution which would be capable of dealing with all the complexities in the world, but through institutions of nation states, which is important. So in a certain sense, the currently existing system still relies on nation states. But if we go back 50 years ago, we understand how and why that evolved, because many countries were emerging out of slavery, emerging out of colonial rule. And the idea was, of course, that bringing them and their representatives to some kind of world government would actually guarantee or was meant to guarantee more freedoms and more justice and more rights to those who are coming from the so-called third world countries. The problem back then, and of course nowadays, is that still we don't have mechanisms that would be able and efficient enough to make the super strong in this international community, so-called, to follow any kind of justice or legal norms.
Would you refer to this? Are we going to see, hopefully one day, more efficient international institutions? What's your feeling? Some universal ones, to say.
You're asking me or Lyal?
No, Leo.
Lyal.
Sorry,
Yeah.
sorry.
Okay, and first of all, Davor, I think, very eloquently put his hit the nail on the head, and it's a big challenge in terms of the legitimacy of international criminal law, and that has to do with its efficacy. Is it efficient? Does it work? And two, is it fair in the large sense? Procedurally, the cases, there's a lot of procedural fairness, but he's raising a larger challenge about selectivity, because if justice is selective, justice has to be selective in the sense that it's going after perpetrators and not the innocent. But that's not what he meant. He meant it's arbitrarily selective. It's arbitrary because you have big crimes being committed by big powers who seem to be beyond the reach. And we're thinking we can talk about United States, we can talk about Russia, we can talk about China, who are not members of the court. And they also have the magic veto at the Security Council. So they have like a get out of jail free card. Now that begs another question. And by the way, UK and France are members of the ICC. And UK, they're big powers, but they have agreed for their own good and for their own legitimacy and their smaller powers to go along with international criminal justice, to support it. And that's a good sign. So it's not all powers are doing this. But still, Davor's key point is a really excellent one. And that is, and you have this in domestic law too, domestic criminal jurisdictions, is that, you know, you get in, it can be very efficient with petty crimes and this kinds of things. When you have white collar crime that injures thousands of people and hits their pocketbook, and fraud and these kinds of things, they have great lawyers. They have some way of getting around it. And it's a challenge between law and power, justice and power. And power and justice in international relations, just like at the domestic level, but it's even more complicated at the international level, is a really difficult issue. So I wouldn't underestimate the force of the arguments that Davor's given voice to just now. And I think they're a really strong possible challenge to justice. My solution to this would be a little bit different. Instead of saying, well, therefore the system is illegitimate, I would say that it's only partially legitimate, and the solution is to, as much as possible, try to strengthen international criminal justice institutions. Not so it can only go after some people, but so that, you know, hopefully the United States will sign on to it. Did you know that on December 31st, 2000, you know, Bill Clinton, that was his last day of office? You know, he signed, the United States, for the United States, signed the Rome Statute of the International Criminal Court. And the Pentagon was against, because they don't want to have the American exceptionalism. They have lots of peacekeepers and also American bases all around the world. They don't want to be subject to international criminal jurisdiction, which is absolutely a scandal, because the International Criminal Court only exercises jurisdiction where the state, complementary basis, is unwilling or unable to prosecute a national of that state, or if it's in the territory, for things like, well, the crimes are crime of aggression, starting an aggressive war, genocide, war crimes, crimes against humanity. So my question for the United States is, for that matter, Russia, China, or India hasn't joined either, neither is Pakistan, neither are some other countries. Are you really saying that you're unwilling to prosecute your own nationals? Or are you unable to prosecute? All these countries are able. That means you're unwilling to prosecute? The excuses that they've given, John Bolton, you know, when he was National Security Advisor, now, you know, quit from the Trump administration. But the Pentagon generally has always said, well, it's a political court. The prosecutor's political. No, it's not true. There's lots of checks and balances in the court. And why do other countries have to be subject? And they don't have to be. They signed on to it because they believe in international criminal justice. They think it's important. And they have the confidence to say, well, you know, if for some reason we're not able or willing to prosecute our own nationals for these extremely serious crimes, we better have the help of the ICC. So definitely this is a serious issue. But it goes back to something else. And that is something really very basic. And that is, you know, like so many countries, 123 countries are members of the ICC, and they do it, the members, because they value international peace and security. And international criminal justice is an imperfect, but it's an important ingredient towards international peace and security. So they understand that. All the EU, just about every country in Latin America, Central and South America, Canada, some Asian states. Lots of African countries have joined the ICC for that reason and shown a lot of wisdom in doing that. Now, the big problem, the root problem, is that 5 countries have a veto over international peace and security action by the UN. And that is something that's a problem that was created by these victorious powers, as World War II came to a close, and it's solidified there in the United Nations Charter, and you can't amend the UN Charter. It's not just by numbers. You also have to have the assenting votes of the permanent members of the Security Council even to get amendment. So reform of the Security Council is extremely important, and that would solve a huge number of problems. Maybe Germany should be a member. Maybe Nigeria, South Africa, Brazil, India, Pakistan, Japan, and maybe water down this veto power, maybe so that you have 2 or 3 vetoes before you block action, not just one, country. Like, why isn't there action on Syria? China and Russia veto. Why isn't there action on Israel? So many resolutions. The United States. Each one of these permanent members have protected themselves, which is not the idea of the veto power. You're supposed to maybe have recused yourself from it. That was never clear in the UN Charter. But instead, they protect themselves or their friends and their friends. So that's why the United Nations, which has all the powers in the UN Charter to do really strong action, without the strong support of its member states, and especially the most powerful ones, the veto wielding powers, you have a real problem there. So we're in urgent need of UN Security Council reform and a revamping of the UN Charter. Unfortunately, I think what's going to happen is that we're not going to see that reform until there's a crisis, because there's just not the political will. Meanwhile, countries all around the world are chipping away at the international rule of law, and I find that very, very worrying. So to your initial question, which is, don't we need more institutions? I'm not sure we need more institutions. We have a lot of institutions, but they have to be strengthened, and for sure they have to be reformed. And first and foremost, the UN Security Council and the way the UN works, because it's really out of date in that respect, and some others as well.
Okay, let's see what's ahead of us. Thank you for having you today, Lyal. Let's see whether we are equipped. I'm sure we're not, but let's see whether we will be equipped for the 21st century challenges that are ahead of us.
Just a final comment to, and I like very much the way Lyal kind of mapped out these issues and potential solutions. And one thing that also will need to change is our predominant understanding of where the problems are. Because since World War II, we are very used to the idea that we need primarily these laws and systems in order to protect either countries or individuals somewhere there in the third world, because they are, developing, and they have all sorts of primitive systems, and they are very capable of doing all sorts of insanities, while we have democratic countries, enlightened countries in the West that primarily whose responsibility is to take care of these laws and rights, and of course the rest of the world. While in reality, we are seeing more and more situations where actually some of these third world countries are there to protect rights either of individuals or stand for certain rights on the international scene against what's happening in many of the Western countries and so-called democracies. So this is also some adjustments that we'll need to make mentally, and also in the school system, if you will, to face the challenges that we are in right now and that are ahead of us.
Yeah, I suppose this is in the definition of universal now. So that was basically the hope. Okay, good to have you here. And
thank you.
Nice to see you this time, and hope to see you next time in the Global Living Room.
Wonderful. Thanks very much for having me in your living room.